Welcome to the Halloween night episode in this year's Halloween-related videos about intellectual property. I'm Julie King of King Patent and Business Law, your witchy guide to all things dark and mysterious in the world of patents, trademarks, copyright, trade secrets, confidential information, and more. You may not know it, but they're all around you every day, almost everywhere you go. You can't escape them. I must warn you, this is for educational and entertainment purposes only. This is not legal advice. It doesn't create an attorney-client relationship, and this does not make me your lawyer. Last year, I covered some trademark tales of terror about popular horror films. This year, I'm talking about patents ranging from the cute accessories to truly bizarre inventions. And this is the episode that gets into the truly bizarre. I'm going to cover strange burial options, exploding graves, and more. First, let's explore some unusual burial options that have received a patent. This patent is for themed cemetery systems and methods. Why settle for a traditional cemetery when you can have yourself or a loved one interred at a theme park for the dead? This invention is for a standalone themed cemetery or themed section of a regular cemetery. The themes represent a particular event, hobby, or location. Possible versions or embodiments, as they're called in the patent world, include a replica of Wrigley Field, where graves are on the field and memorials are in the shapes of baseballs, bats, home plate, or other baseball items. A replica of a racetrack that includes a columbarium with a race car on top of it, a replica of a golf course, a replica of a casino, a model train theme, quilting theme, and so on. The price of being laid to rest in one of these themed cemeteries depends on where in it you want your remains to be. On the field is more than in the stands. The inventor also imagines advertising space could be sold for the same spots it's sold in for the actual venue. How do you get a patent for such an idea? You draft the claims to describe the themed cemetery and possible elements, like having a portion with advertising space. This patent has expired for non-payment of maintenance fees. So if this sounds like your kind of business opportunity, you won't be hindered by this patent. You can't get a patent for it on your own, though. Once something is out in the public as a patent, published application, or some other way, it's what's considered prior art, which means it prevents something identical or very similar from being considered novel enough or new enough of an idea to patent. So maybe a themed cemetery is a bit more than you want to think about right now. How about a haunted house themed hotel? Here we have a patent for a themed interactive environment in the form of a motel or hotel and method of operating the same. The invention discusses incorporating special effects in the guest rooms and common areas with a central control room where personnel manually deploy the effects and some automatic triggers for effects. Effects include noises, taps turning on by themselves, lights flickering, projections of ghosts, shaking of furniture, and more. Some automatic triggers include having heat and weight sensors in the floors to sense guests nearby. One of the examples the inventor uses is if a guest is going to sleep, the bed may shake. This is a brand new patent issued in 2023. I have to wonder if it was inspired somewhat by the movie Cabin in the Woods. The owner of the patent rights, who is not the inventor, is appropriately named Adrenaline Technologies. Owners of patent rights are often not the actual inventors. While the inventors must be listed on the patent, the inventors can give their patent rights to someone else called an assignee because they are assigned the rights. Sometimes inventors sell their rights. Sometimes they're automatically assigned through an employment agreement. So be careful about inventing things related to your job, even on your own time. Next, we have a patent that is minorly famous in the patent world for being innovative, weird, and almost certainly unconstitutional. This mad scientist type invention from 1930 is innocently called apparatus for obtaining criminal confessions and photographically recording them. You'd never guess from that title that one of the main features of the invention is A skeleton with a camera hidden in its skull. They say no one expects the Spanish Inquisition, but who expects to be interrogated by a skeleton after arrest? Another feature is bulbs in the eye sockets to blink to give the impression that it's real. Sorry. The skeleton is behind a transparent panel with lighting such that it appears more ethereal, and it's covered in a thin veil to make that effect stronger. The questions come through the mouth of the skeleton from a megaphone connected to a microphone used by the Inquisitor at a console behind the panel at the back of the skeleton. The point of this invention is to instill fear in the subject so that they confess, and to record the confession so they can't deny they confessed. Oddly enough, the inventor thought that being interrogated by a skeleton with flashing eyes and a voice coming through a megaphone wouldn't count as getting a confession under duress, which would, of course, render it inadmissible as evidence. So, if that one isn't deranged enough for you, let's try this one. This is a violent patent for improvements in coffin torpedoes. That's right, coffin torpedoes. This patent from the late 1800s was intended to help prevent grave robbing or other grave desecration. Essentially, it attaches torpedoes to the coffin and trigger wires to the body, such that the torpedoes shoot up and cause death or injury to the person doing the grave robbing. Now, I want to note that this invention is for an improvement in coffin torpedoes. So that implies it was worth improving the ones already in existence. This should make you think twice before messing around with any graves from the 1800s. Pick a different decade. Lastly, we turn to a patent for something that was intended to be a nice reminder of the dearly departed, but sounds like a perfect way to create the basis for a horror movie series. Here we have a patent for a doll containing an urn in which to store someone's ashes. The invention includes a voice recorder that can play a message recorded by the deceased prior to their death. At least one hopes that's when they recorded it. This doll could be shaped to resemble the deceased, which isn't creepy at all, or take the shape of a beloved stuffed animal. It's supposed to be a sweet remembrance, but if you've paid any attention to horror movies in the last few decades, your mind, like mine, may wander to the Possessed Chucky doll series or the Possessed Annabelle doll series, or any other number of possessed doll creatures in horror movies. Dolls creep a lot of people out in the first place. Putting ashes and a voice recording in them seems like asking for trouble. So the tasty patent treats to remember from this episode are: number one, once a patent expires, the owner of the patent rights loses those rights. That means they no longer have the right to stop anyone from making, using, or selling the invention. However, because there was a patent, no one else can get patent rights for that exact invention or one similar to it. They'd have to make improvements or combine it with something else. The same goes if there was an application that was published in the USPTO database but never made it to being a patent. If an invention was made public like that or in any other way, it counts as prior art. Number two, all inventors must be listed on a patent. The inventors can assign their ownership of patent rights to someone else, though, called an assignee. Sometimes that assignment is automatic through an employment agreement, so be careful about those terms and inventing things related to your employment, even on your own time. Number three, patents can be issued for weird and even disturbing inventions. While they can't be issued for things that are illegal or for an illegal purpose, if the application manages to describe the invention in a way that it shows it can be used for a legal purpose and doesn't mention the illegal purpose, like a pipe that's obviously for marijuana smoking but technically can be used for regular tobacco, you can get a patent. Now, there is a flat prohibition on getting a patent for anything encompassing a human organism, thanks to the American Invents Act of 2011. While it does appear that genes, stem cells, animals with human genes, etc., can be patented, actual human life forms can't be patented. This means you can perhaps play Dr. Moreau and get patents from your animal-human hybrids, but you can't get a patent for making a monster out of human parts like Dr. Frankenstein did. The government has its limits for mad scientists. And remember, can doesn't always mean should. I have one more episode in this series this year specifically designed for the Day of the Dead tomorrow. I'll be talking about the ways in which a patent can die and be resurrected. My contact information is in my bio, so please don't hesitate to reach out and connect or ask questions. Thank you so much for watching. Have a happy, happy Halloween.